Good morning, ladies and gentlemen, and welcome to this CICV presentation on conflict avoidance processes. My name is Len Bunton. I'm on the left there. I've been involved in the construction industry for a long period of time, specialising in dispute resolution and dispute avoidance. And I've been involved with the forum now for about 12 weeks, and I'll talk about that in a minute. The presenter is Martin Burns. Martin, welcome. Travelled all the way from Birmingham with us today. Martin is head of ADR research and development. So a few words about the forum first. You see there the member organisations on your screen. It's amazing how this forum has been put together in the space of 12 weeks, and the bodies that are shown there represent the construction process from inception, design, procurement, construction phases, and facilities management. Okay. 51 different organizations involved. There are 24 member organizations and another 27 contributing members, and incredibly over 100 individuals involved. There are currently 7 subgroups which cover health and safety, employment, commercial management, communications. We have an interesting subgroup that is looking at the future of the construction industry. What will it be like post the virus and what changes are needed? We also have a skills group which is dealing with apprenticeships and these sort of areas. And we also have recently added a consultants group which brings onto place engineers, quantity surveyors and architects. So it's a truly construction industry-wide organisation. One thing I would like to mention, we currently have out for consultation what's called Blueprint for the Industry. We have put that out to as far-reaching corners of the construction industry as we can, and are asking people to contribute with their views as to how the future picture of the construction industry should be. Because I think one of the important things that's come out of the virus has been the fact that people want to see the construction industry in this country taking a completely different shape. So the idea was to get the people that are in the industry to contribute and to tell us how they see the industry should operate in the future. Okay. Now, I just want to mention more or less as a lead in to Martin's presentation. There's a next slide, Martin, please. I'll leave the second bottom process till the end of this, but just to mention about the adjudication process and what the current picture is on it. As everybody knows who's listening, adjudication came into play in 1998. It's still going strong. There must have been an average of 1,500 appointments a year by the nominating bodies. And in March and April, between March and April this year, the RICS made over 400 appointments. And I think by and large, it's considered that adjudication has been a very successful process in terms of assisting contractors' cash flow, which are way back in the days of Sir Michael Latham, that was the objective. However, I think there have been recently some emerging trends. Some of you may be aware that more often than not, when an adjudication starts, the adjudicator is subjected to a number of jurisdictional challenges. These, in many ways, are tactical, but inevitably, even if you do get a successful decision in adjudication, the losing party often says, well, I'm not going to make any payment because there are jurisdictional issues. Now, that means that the successful party has got to go to court to try to get his decision enforced, and that takes a considerable period of time and requires both sides, in fact, to engage solicitors and often counsel. So you have to question, what is the value of a process that doesn't give you what it says in the tin? You get a result, but you don't get your money. That's completely hopeless really in the current climate. The other factor, I think, and I'm sure Martin will endorse this, is that we've seen a trend recently from the major employers in the United Kingdom to say, I don't want any disputes on my contract. I want to build my project and use it for what it's intended to use, and I don't want the distraction of major construction disputes. So that really sets the scene as to why the RICS has done a fantastic job in introducing the conflict avoidance process into the United Kingdom. And I'll now pass over to Martin to take you through how this process operates in practice. Thank you.
Thank you very much, Len. Do you know what? I was in a bit of a panic this morning when I was preparing for this webinar, and I emailed Len very early on. And the question I asked him is, what are you wearing? Are you going to be dressed smart? And part of the reason for that is I've given a few of these webinars since lockdown, and I've attended launch events where I've been speaking. And by and large, lockdown has tended to see people giving presentations dressed kind of casually. I was talking to 3 guys working for the government the other day, and they're all wearing t-shirts. The only time I dressed up for one of these webinars was when I was speaking at a launch event for the Construction Industry Council's model adjudication procedure for low value disputes. And the keynote speaker was the Right Honourable Nick Rainsford, who was Tony Blair's construction minister and responsible for bringing into being the Construction Act and, of course, adjudication. And also on that forum was Graham Watts, who's the chief executive of the Construction Industry Council, and Fergus Harradence, who's the Deputy Director of Construction for the government department that looks after construction bays. I thought, well, I better dress smartly, and I wore a suit and tie and everything else, and we all came up on screen, and I was the only one wearing a suit and tie. Everybody else was wearing t-shirts. Nick Rainsford looked like he just got out of bed. And since that, I've tended to wear just casual. And but I wasn't sure today, but I asked Len just in case, and he told me he's forgotten how to do a tie, so that means we're fine. We can go as we are. To thank Len for setting this up, this webinar. He asked me to, and we've had lots of discussions over the last couple of years, in fact, about how the construction industry is gaining an appetite for methods and cultures, if you like, that help to avoid and manage conflict rather than wait till it's too late and find people are involved in a very horrid dispute that's ending up in the hands of lawyers and gone to adjudication, arbitration, or at the very worst, litigation. And it's probably worthwhile just giving a little bit of history of how RICS became involved in this, because this appetite, I say, the industry is seeing is actually one that the industry has produced, not RICS. And RICS has reacted and responded by trying to help industry bodies to put together processes, methods that can underpin work that they are already doing in the industry to try and have a different kind of culture, a more collaborative culture, a much more cooperative contractual arrangements, which trying to do away with this sort of traditional established convention within the construction industry that there will be disputes. You know, the whole language of the construction sector is geared towards disputes. It's about winning and losing. It's about us and them. And CAP actually came out of a meeting initially that RICS had with people representing the London Underground and Transport for London, and some of the key project partners that were involved in a £7 billion project to upgrade the London Underground. And those included the likes of BAM Nuttall, Laing O'Rourke, Costain, and Skanska. And they came to RICS because they had already been demonstrating an appetite to work together much more collaboratively and to share risk and to have a more open and transparent relationship. And open and transparent is not that easy, because it's a very difficult thing to do, to have conversations about difficult subjects rather than hand matters over to lawyers. And with this group, RSCS developed what was at that time called the Conflict Avoidance Process, and those gained this acronym CAP quite easily. And the idea was that we would help them to put into place something that meant that they could avoid losing control over disputes. When I say losing control, the image that these organizations painted for us was that they would be around a boardroom talking and having an issue which they couldn't agree on, that they're just simply failing to have some sort of settlement on. And what would normally happen is that they would then, or one of them would instruct lawyers and initiate an adjudication, or maybe even if it was a matter that deserved it, start an arbitration on that. And what they were telling us, of course, is that the commercial directors, the people who were very much involved in trying to ensure that the projects were a success, and that from the project partner's point of view, that they were working in a way that made them a profit, that they lost control over the dispute. Once it's gone to adjudication, then the outcome is not within their control. And what they wanted to do is to build on the collaborative working arrangements that they were already developing within their relationship, to have something that came in before adjudication was necessary. So they realized that in some cases then there'll still be matters that might need to be adjudicated or arbitrated, but that they wanted to reduce the amount of claims and disputes that could severely damage their relationship. And it's interesting, I was trying to work out myself at those meetings, what were the priorities? And they had three priorities, which were quite naturally, one, to reduce legal spend and the costs that were attached to dealing with disputes. They were also very keen, TfL, of course, to manage anything that put their reputation at risk, brand reputation, that is, particularly since TfL was publicly funded. To have a reputation of being constantly involved in disputes is not very good, and spending money from the public purse on lawyers and legal cases and adjudications was not good for their reputation. But it seems quite clearly that the major priority, the number one priority that all these organizations had, was to maintain good relationships, because they realized that they'd be working together for a long time. The London Underground upgrade was a project that envisaged to last 7, 8, maybe 10 years, and could go beyond that as well. That working together, they didn't want that relationship to be constantly damaged by disputes that were going to adversarial processes. They wanted RSCS to help by coming up with ideas and a mechanism that would help them to, in the first instance, resolve some existing claims. There were some legacy disputes that had been sitting around for quite some time, major legacy disputes as well, involving multi-millions of pounds, that they were still trying to find a way through. That clearly they wanted something that was going to be fair and reasonable in terms of the outcomes. It's not that they felt that adjudication or litigation was necessarily unfair, but there was this feeling that in many cases you could go to adjudication or an adversarial procedure and neither party was entirely satisfied with the outcome. And of course, because they don't have any control over the outcome, there's not a lot they could do about that. As I say, maintaining working relationships was a key priority. And they wanted certainty of outcome. You know, they wanted to be sure that this was an outcome that they could live with and go forward with. They also wanted a process that would help to reduce the potential for future conflict. So it wasn't just about resolving existing claims and resolving emerging disputes before they ended up going to adjudication or arbitration. They wanted, as part of this change in culture, to reduce the potential for conflict going forward. over quite a short period of time, I think it was about 2 or 3 months, RSCS helped to develop a procedure, the CAP procedure. And this was a CAP procedure that was baked into the NEC formal contracts that were used on the TfL project. And what's unique about it, or different about it, it's not entirely unique, is that it works to prevent disputes just as much as it does to resolve them. Part of the reason it does that is it gets in much earlier than adjudication would. Adjudication happens very often when the issues around the dispute have been well rehearsed, when lawyers have probably spent months, and in some cases maybe even a year or so, preparing for the adjudication and getting everything put together in order to run the adjudication. What they wanted is something that came in early, that helped to prevent what may be emerging differences from boiling over into disputes and then becoming a situation where parties became entrenched. They wanted something as well that was flexible, and interestingly, CAP has been used by Transport for London on at least 40 occasions on disputes that range from somewhere in the region of £20,000–30,000 dispute to one that was well into the millions. When I say that's probably over £200 million potential dispute, which was resolved by CAP. What they wanted is a process that wasn't too dogmatic, wasn't too prescriptive. They wanted it to be flexible. And in every case where they've used it, it has been used slightly differently. The process and the timetable and everything else has been adapted to suit the nature of the issues that needed to be dealt with. And they also wanted it to be cost effective. And by that, they wanted to have control over what the cost for this process would be. And also, I remember in our early conversations, I talked about dispute boards, and they pushed that back because they felt that dispute boards were an upfront payment, and they only wanted to, something that they paid for when they used it. And that's something that's very much embedded within the CAP process, that parties don't pay for the setup of CAP, they don't pay for the fact that CAP's there, they only pay for CAP when they use it. And also the price point for CAP is something that is agreed with the parties. So there is no standard fee scale that one can say, well, that's what CAP costs. It's something that is negotiated between all the parties in terms of what they are able and prepared to pay for the CAP process. How it works in practice is very, very simple. And I'm using the phrase now that Sue Barrett, who was project director for Transport for London, used. She said, we want somebody to come in and bang heads together. That were her words, but effectively what they wanted was somebody who was impartial, who was very credible, who was a subject matter expert, i.e. that at the heart of every dispute is an issue or a question that needs to be answered. And they wanted somebody who was an expert in that matter, on the question to be answered, to come in and not act adversarially. So it's not adjudication light. It's not taking evidence from parties and then coming up with an answer. It's about acting inquisitorially, finding out precisely what it is that the parties are disagreeing on, asking questions, visiting sites, asking questions of people on the ground as well, and then providing a report. And in that report would be their findings on the issue or issues which were emerging and were potentially going to escalate into full-blown disputes, and to make non-binding recommendations on how those matters could be resolved. And that non-binding recommendation or recommendations was given to both parties, and they would use that to help them resolve their dispute. In some ways, it provides them with a risk analysis. It's basically telling them, this is the likely outcome if you do take this to adjudication and you do spend a fortune on the adjudication process or arbitration or litigation. And in doing that, it promotes ownership of the dispute with the business itself, with the commercial directors and the commercial managers. The people retain control over the outcome. So I've often described it as the boardroom maintains control over the dispute, and it's not handed over God forbid, to lawyers. If anybody thinks I'm being disparaging about lawyers, I do apologise. I'm a lawyer myself, so I feel like I'm able to do that, and I've spent my entire career trying to persuade people not to use lawyers if they can help it. Using the Transport for London as a case study, what do they want? Well, it was already clear that TfL and its project partners were committed to a working culture that was about sharing a risk and about avoiding conflict where possible and being open and transparent, and to have all of this, because it doesn't matter what you have in a contract and what a contract says and how well it's written, or how committed people are about trying to be more open and transparent and avoiding disputes. People are people, we're all human, and there'll be times when we can't agree on everything. When we fail to agree, then the potential for that disagreement is for it to become a dispute. And so what they were looking at is something that would underpin all of this collaborative and transparent culture they were bringing into the business to help them deal with disagreements early. TfL worked with RSS. We developed a process which we now know as CAP, which is baked into the NEC forms that they do. So £7 billion worth of contracts include the provision for CAP. The CAP process is also baked into framework arrangements that TfL use with hundreds of their suppliers. The result has been immense. As I say, CAP's been used about 40 times on a variety of issues with different contractors. It has also been used not just with the project partners, the tier ones, it's also been used between tier ones and other suppliers across the supply chain. And then every time it's been used, it has actually led to a settlement of disputes. And there is an amazing graph, hopefully I might have it in this slideshow here, which demonstrates the impact that CAP has had with Transport for London. It's prevented an enormous amount of resource and time and effort and money being allocated to resolving disputes over long periods of time. Here's the graph I refer to, and this is something that I have borrowed from TfL and with their agreement. And a few of you may have seen it before, but it's just such an image. I think it's very indicative of, if you see from 2010 to 2016 there, and 2016-17 was at the time where CAP was introduced into the contractual matrices with TfL and their project. That, you know, it quite clearly claims and compensation events and disputed events were the norm and were inclined to increase as the contractual arrangement progressed over a period of time. What we see also from this graph is once CAP was introduced, there was an immense impact in terms of the numbers of claims and numbers of issues that were raised and the potential for those to turn into full-blown disputes. Almost dropped off the edge of a cliff. And interestingly as well, in terms of a number, we had the Commissioner for Transport for London launch the Conflict Avoidance Pledge, which I'm aware most of you have signed up to. And the Commissioner for Transport for London used very interesting numbers to give emphasis to the impact that CAP had on TfL and its projects in terms of disputes and the cost of disputes. And he said that traditionally, the cost of resolving what he would describe as a smallish dispute would be somewhere in the region of about £50,000. That's £50,000. A larger dispute, they were talking £500,000 and upwards in terms of legal costs and spend to resolve those disputes. In all the cases where CAP had been used, averaged out, the average cost of resolving a dispute was £12,500. And that in itself, I think, was a significant message that got across both to the people who attended that event that he was speaking at, and we've been using since to emphasize just how useful CAP can be. So what is CAP? The thing is, since we introduced it to TFL, we saw just how effective it would be, and we've then, as an organisation, started to talk to other organisations. I have counterparts at the Institution of Civil Engineers and the RIBA and Chartered Civil Arbitrators, and together we formed a coalition called the Conflict Avoidance Coalition Steering Group, and we have been promoting the whole concept of conflict avoidance, and it was the steering group that developed the pledge, for example. And we also looked at conflict avoidance procedures like CAP, but not on their own. But the dispute boards, I think, do have a place in this, so there's early neutral evaluation. But we were able to hone down precisely what the CAP process could be and how useful it could be for other organisations. In terms of its key features, well, the thing is, initially, parties have to agree that they want to use CAP. And what we've seen that companies like the Urban Growth Company, which is responsible for the development of Birmingham International Rail Station, which is just about to get going, and they have included within their framework arrangements and within their tendering provisions that there will be an inter-party agreement to use CAP as and when it's necessary, or the parties think it would be useful. Thing about it as well, it's project specific. So when it's been rolled out for the Urban Growth Company, they're using it specifically on the Birmingham International project. It's in the framework arrangements for that. It's in the individual contracts as well. And for that reason, it can be adapted in terms of the timetable and the schedule to suit the kind of dynamics of that particular project and how it works for that project. It can deal with specific issues that arise, and it can work to help resolve issues well before they start to develop into full-blown disputes. So a CAP process can be used with people who have already started to ask questions. Well, let's bring in somebody to give us a neutral view on this. In terms of it working as well, as I say, it's an inquisitorial process. It's not meant to be adversarial, but all the parties involved are allowed to make representations, to talk through to the CAP, to provide documentary evidence in support of the arguments that they want to put forward. As I say, it's a flexible procedure. Interestingly, we've seen contracts where lawyers have got their hands on the CAP process and set out a very prescriptive methodology for CAP. I've seen it in an NEC form. What was interesting is that it was used on the NEC form, but it didn't follow the prescriptive timetable and process that was set out by the lawyers in the CAP clause in terms of when it commenced and how the appointment worked and how the meetings and visits and such like were conducted in terms of timetable and the timetable for the decision. And the parties in that case looked on the way the clause was worded as an objective timetable rather than a directive, and it worked. So in that particular case I'm referring to there was a 2-week schedule from the time parties decided they want to use CAP to the time when the recommendation was provided. But the dispute itself was of immense complexity, and the CAP lasted 4 weeks, which in my mind is actually probably the longest that a CAP process has lasted, from the time that parties want it to begin to the time they get a recommendation from the CAP. A CAP can be one person, as I say, an expert who is very credible in the subject matter that's been in dispute, or it can in fact be more than one person. The original vision for it was that it could in fact be 3 people if that's what was necessary. In every case we've seen it used thus far, it has in fact only involved one CAP professional, who is the person who would make the inquiries, provide the report and give the recommendations. But in many of the cases where a CAP's been appointed, they have used both internal and external assistance. I think a good example for external assistance was where a CAP was appointed to determine a compensation event matter, which included a question around ground conditions. And with the parties' agreement, the CAP looked at a particularly geotechnical question and said, well, I need some person who really knows their stuff about this. And the CAP appointed somebody who was a geotechnical engineer, who provided assistance and a report, and that report then fed into the CAP's report. So it was, the external assistance was for the CAP, and that report was then used by the CAP to inform his final report and recommendations, which were produced at the boardroom. Timescales are flexible, as I say. The longest CAP process I've seen thus far was in the region of 4, could have been 5 weeks. The shortest one, from the time the CAP was appointed to the recommendations being made and accepted by the parties, was a matter of days. I confess that was a relatively straightforward question. The CAP, who was a splendid expert on the matter that was at the heart of the dispute, sat down with decision makers from both sides on this particular question, and over a period of 2 or 3 hours at a meeting, plus a quick site visit, delivered recommendations which both parties immediately accepted. So that was a perfect outcome in those cases. And in terms of outcomes, the CAP provides recommendations which are designed to inform a negotiated settlement between the parties and give them a sense of the risk that would be attached for taking a matter further through arbitration or litigation. Non-binding recommendations, fully reasoned out, so they're fully explained. Interestingly, 1 or 2 of the contracts we've seen include a facility that if a CAP makes a recommendation fully reasoned out and one party decides that they don't want to accept it, then they should provide full reasons for their non-acceptance. I haven't seen it work in practice, but the idea behind that is that if a CAP recommendation is fully reasoned out and fully explains, then the parties can use that to reach their own settlement. They don't have to simply accept all the recommendations, but they can use the recommendations to help them to negotiate their own agreement. But if one party simply says, I'm not accepting that, and walk away, then if they were required to fully reason out why they're not accepting it, it makes it difficult for them, if those recommendations are sound, to just push their case further. That's the theory anyway. The thing about CAP is it's something that parties agree to do, and it has to be demonstrated in a commitment, and that commitment doesn't simply go to putting a clause in the contract to use CAP. It goes to a commitment to be part of a more collaborative working environment, to be much more open and transparent, and to face up to issues early and try and deal with them. I remember talking to a project director of one of the tier 1 contractors who were using CAP after a rather difficult matter being resolved, and asked him about this, commitment to being open and transparent. And he said it was very difficult. So we're not saying that it's always going to be easy, but he also said that it was much better than going to adjudication. So there we have that. The parties have to agree precisely the process. So there's a framework process that is available, and I think Len's shared that with people who are attending this webinar. The process itself is one which is very straightforward, but it's flexible, and parties can agree to adapt it to suit their own particular needs, and particularly in timescales. Also, they can agree what the outcome should be in terms of how to treat the recommendations. It does require, as I say, parties to cooperate and to work together, and to work with the CAP, to cooperate with the CAP, because the CAP's role, as I say, is inquisitorial. He or she needs to ask questions, needs people to be fully cooperative in giving the CAP the information that's needed in order to help the CAP come up with a report and recommendations that are going to be useful. And flexibility is something I've mentioned a few times already in this presentation. I think it's key. Don't think that CAP is a box that you get into and that's the process and that's how it's always going to work. It's flexible and people can adapt it. Once a CAP's appointed, I think the CAP professional is very much involved in managing the process and taking control over the process, but it needs the cooperation and assistance of the parties who are involved. What I really like about how it's worked thus far on the cases I've seen is how it has provided innovative solutions, because sometimes parties get bogged down in some precise detail and not sometimes able to look at the problem objectively. And what we've seen is CAP recommendations provide an innovative solution that parties haven't really worked their way through. Because remember, this is not like an adversarial process where it's about determining the answer to a question in the legal context, parties' rights and their rights under the contract. It's about helping parties to find a way through an emerging problem or a problem that's settled or began to settle, and finding a way that would help both of them dispose of that problem and to get on with life and to deal with what's necessary, which is the day-to-day work. The whole thing about CAP is it's about finding a solution to the problem. And that's another good thing, because in adjudication, for example, an adjudicator is very limited. An adjudicator has to answer a question that's been put in a referral. An adjudicator can't say, well, if you phrase that question differently, or if you looked at this in a wider context, the adjudicator can't do that. An adjudicator can only answer the question that has been put to him or her for resolution. The inquisitorial nature and the more flexible nature of CAP means that the CAP can engage with parties and help them find a solution and to work with them. And that means that the CAP has to be somebody as well who is good at talking and communicating with parties. We talk sometimes about mediative skills, but mediation is not a process in itself. It's techniques, and it's using some of those techniques to help break deadlock, to help get people out of entrenched positions in their negotiations, and to work towards finding a solution to a problem. And the fact that it comes in earlier makes it work much more effectively. And of course, in doing so as well, finding a solution that everybody is agreed and signed up to means that the relationship is one that's maintained, particularly if you're involved in a project that has a long lifespan. This is just a sample clause, and this is just meant to help people. Len and I, in fact, worked on this just over the last few weeks. The idea being that, you know, if people wanted to include a clause in the contract, what would it say? What kind of points would have to be drawn out in a clause? And so we came up with this as a kind of a model, let's say sample clause or a model clause that people can draw on, can use, can adapt for their contracts. I've cheated a little, because what I'm doing in some of the wording here is I've drawn on provision that's set out in the framework arrangements that Transport for London did with one of its tranches of suppliers. I think it was about 125 suppliers on a framework arrangement, and looked at that. I thought, well, this is something that we could actually adapt now into a clause. We wanted to keep the clause quite simple as well. We didn't want it to be one that was very complicated and long, and I think it's good. I like it. And the idea of CAP in terms of its neutrality as well is that RICS maintains a panel of people who we've trained up to deliver the CAP process. I want to say we in fact engaged with industry bodies to help us as well, because we wanted them to make sure that anybody who was acting as a CAP understood how they wanted CAP to work for them. And this then gives parties a sense that any person acting as a CAP is neutral, is independent, if they're seen to be vetted and approved and indeed nominated by an independent organisation. When RICS has worked with other organisations in setting up CAP, we were put together a panel for the client, a CAP panel, if you like, specifically for that project or for that client. And that panel is one which is agreed with the parties. So the parties never ever get a person appointed as a CAP and they say, well, who is this? What are their credentials? They will already know who that person is, because that person is on a list which has already previously been agreed with the relevant stakeholders on that contract, on that project. How to get CAP into arrangements. We've seen it used in bespoke agreements. We've seen particularly tier 2 contractors who've included it as a provision when it hasn't been provided for in the contract. So they've said, or they're aware of CAP, so we want to use it. Can we adopt it? And they've used it when an issue has arisen or started to arise, and they've made a bespoke agreement to adopt CAP. This bullet point here, agreement with the CAP provider, that's RICS. And what RICS has done is provided very precise terms of reference, the questions that needed to be addressed, the timescales, fees and expenses, everything else that the parties want the CAP to undertake. I've mentioned outcomes again. Parties agree in their contract what kind of outcomes they want in terms of non-binding recommendations, fully reasoned out. What are they going to do with those recommendations? In some cases, parties can enforce that the recommendations will become binding. That's entirely up to them. But they will necessarily need to put within their contract what it is that they want the CAP to do and how they want the matter to be finalised. I was talking to a guy recently who's been using CAP, and he described it as a form of early neutral evaluation. And I think it's what he says has some merit, because CAP is part of the ADR matrix, if you like, the alternative dispute resolution matrix. It's a method of resolving a dispute which means that parties don't end up in court, which is precisely a definition of ADR. But it's not necessarily just early neutral evaluation and providing a risk analysis. It also draws on other methods of ADR, such as mediation. And I think anybody who's acting as a CAP professional, who's attending a boardroom where there's people who are not entirely in agreement with each other, that somebody who has mediation skills and techniques has a bit of an advantage, I think. And mediation techniques and skills are things that people have naturally, the ability to help people to negotiate, to talk to people, to communicate, and to help them communicate with each other. It's also been described as well as drawing on the process of expert determination, which some of you may be aware of. An expert determination is where somebody who is a subject matter expert makes a decision on a dispute, and that decision could be binding or non-binding. The role of the expert determinator is very much an adversarial role in many cases, but there is also anticipation that experts apply their own knowledge of the subject matter and make their own inquiries. And so if you look at the way CAP is set up, it kind of draws on methodologies like early neutral evaluation, mediation, expert determination, which are firmly established in the ADR matrix. And it brings all of these together into a process that works and is flexible. Talked about possible outcomes as well. So the key thing about the CAP is that it is an impartial process. What parties are getting is expertise and an answer to a question which is not one that has been promulgated by an expert of one party's employee or instructed by one of the parties. Most cases thus far, it's involved non-binding recommendations in a fully reasoned out report. So if the CAP is answering a question, and the CAP needs to also explain how the CAP has come to that answer. And the reasoning is fundamental to whether the parties accept those recommendations, because that reasoning provides the risk analysis they need in order to determine how they're going to go further. CAP, we've seen it often. CAP attends meetings with the parties, and so it doesn't just deliver a report and does nothing with it. In the cases we've seen thus far, the CAP has attended meetings and walked and talked to the parties through the report and the recommendations for settlement. Because they're non-binding, it's entirely up to the parties what they do with the CAP recommendations. What we've seen in practice is that they've used those to inform their negotiations and help them reach a settlement which they will agree on. And in every case as well, it's not necessary that they agree entirely in accord with all of the recommendations made by the CAP, but what the CAP recommendations do is give them that platform on which to base their settlement. Said a few moments ago, parties can choose to be bound by the CAP findings at any time, so they can agree afterwards, well, these are good, these are sound, let's accept them and be bound by them, or they can agree beforehand. We haven't seen that, the truth be told, but it doesn't prevent parties from doing that, to agree before the whole thing happens that they're going to be bound by these findings. I'm not sure that that's going to be very popular, but you never know, some parties might want to do that. And so effectively what a CAP report does, it provides parties with an impartial analysis that they can use to determine what they're going to do going forward and any risks associated with taking a matter to adjudication or arbitration, etc. That's me now. These questions I think were formulated by Len, and I just want to bring Len in on this again now. If you like, that's me finished walking through, and I anticipate there may be other questions that the audience here would like to ask. And by the way, if you can't get a question off to me now or Len during this webinar, do feel free to email either us or both of us afterwards, and I ensure that you'll get an answer to any questions you may have. Even happy to have conversations with people individually if that's the case.
Martin, if I can come in, I think it's maybe worth identifying to the audience the traction that CAP is gaining in Scotland. And as an example, Scottish Future Trusts, 2 of the hubcos have signed up the Contract Avoidance Pledge, and the other 3 are about to do that. you've been talking to various people in this country. Can you maybe just share views that you're getting back about this?
Yeah, certainly. In fact, I've been talking to people across England, Wales, Northern Ireland, and Scotland about CAP, and by and large, there's been quite an appetite for it. But I haven't seen more appetite than there is in Scotland. And as you say, Len, Scottish Future Trust, who we talked to just not so long ago, and they had some questions that they just want pinning down on CAP. But it's quite clear that they exemplify what's happening in Scotland in terms of this immense appetite. We've seen it. We're constantly now having conversations. In fact, I have a conversation with the Scottish Government later today, because, as Len said earlier, there is a drive by government to see a change in the way the construction sector works and the way it operates, and to move to much more collaboration, cooperation, and dealing with disputes much more effectively and much earlier. And we've seen this in Scotland. It really, really gained traction, and it's moving quicker, I think, in Scotland than anywhere else. But by and large, what we're seeing is government offices right across the UK and promoting this whole idea of a much more conducive way of operating the construction industry than people have been used to in the past. But I hold up my hands and say I've seen it much more positive reaction and much more willingness to engage in this quicker in Scotland than anywhere else.
The third question there, most of the bodies involved in the forum represent SMEs. Now, I know we've discussed this, but there has to be a process that goes right down the supply chain here. It can't just be between the employer and the contractor. And I know that we're working and looking how that can be impacted, but I think that's going to be very critical to the whole process that SMEs, can go down this route as well. You agree with that?
Oh, absolutely. And what we saw with Transport for London, for example, is when they started the CAP process, it was very much about dealing with issues between TfL as the employer and for project partners, tier ones. But over a period of time, it has gradually started to flow across the supply chain, and we're seeing smaller contractors now start to get involved in it. And indeed, I think there's something like 125 tier 2, tier 3 contractors who signed up to CAP on the TfL projects. The thing about it is that I mentioned it's a flexible process, and that flexibility goes to how it operates for particular clients, how it operates on projects, and its price point. And all of those things can be resolved and dealt with by the parties. And particularly when dealing with the supply chain for SMEs, what I like about the CAP process, it can be used to bring somebody in, give an answer to a problem, and enable that problem to be resolved very cost effectively, very cheaply, at a price they've already agreed in terms of their working arrangements.
Okay. Now we've just got a couple of other slides to finish off on. If you could just put these on, please. And for those of you who are interested, if you have a look at the forum website, you'll see the various contractual and commercial papers that have been made available to the industry. These are available to have a look at. Next one. Okay, just to finish off, thank you, Martin, for that presentation. Absolutely first class. I do want to mention a couple of things. There'll be a future webinar in about a fortnight, which will be an update to the industry on the issues relating to the startup on sites again and productivity considerations. So I hope you'll sign up for that. I'd like to thank the organisers, Ian Mason and Alicia, for the work they've put into this, and to all of you for your attendance at this morning. I hope you found that interesting. from my perspective, this, I think, is going to be a game changer for the industry in Scotland. It will bring cultural changes, and I honestly hope there'll be buy-in, because I believe this could be the first step in a major change in the way the industry is operating in Scotland. So thanks to everybody, and I hope to see you soon. Thank you.
Thank you, Len. Thank you all.